HOA sued me for my 1,600 acres. After trial, they lost their only access. Hello, everyone. Before we begin today's story, we would like to ask you for one small favor. Please subscribe to the channel and turn on the notification bell so you will not miss any of our latest videos. It only takes a moment, costs nothing, and is one of the best ways to help us continue creating powerful, emotional, and dramatic stories like this one. Your support means more to us than you can imagine. Also, let us know where you are watching from today. Share your city or country in the comments below. Thank you so much. Now, let us return to our main character. Mr. Cole, are you asking this jury to believe that one man can own the only road used by 400 families? The HOA attorney let the question hang in the courtroom. He did not look at me. He looked at the jury. Behind him, a map glowed on the evidence screen. A thick red line cut across my family's 1,600 acres, ran between two cattle pastures, crossed Miller Creek, and ended at the black iron gates of Maple Ridge Estates. My road, their only way home. Rain tapped against the courthouse windows. The air smelled like damp coats, old carpet, and coffee that had been burning since sunrise. Somewhere behind me, a woman whispered that I should be ashamed of myself. I kept both hands on the cracked leather folder resting in my lap. Across the aisle, Rebecca Langford smiled. She wore a pale gray suit, pearl earrings, and the same controlled expression she had used on television when she accused me of holding an entire neighborhood hostage. Her blonde hair curved neatly against her jaw. Her nails were polished the color of red wine. Only her right hand betrayed her. She kept rubbing her thumb across the edge of a silver pen. Back and forth, back and forth. I purchased the final adjoining parcels after he died, bringing the Cole Ranch to 1,600 acres of limestone hills, cedar woods, spring-fed pasture, and red Texas soil that stains your boots long after the rain stops. Maple Ridge had not existed when my grandfather built that road. There had been no stone entrance, no clubhouse, no identical mailboxes or manicured lawns. Just scrubland owned by a developer who needed temporary access while he constructed a public entrance on the north side. My grandfather allowed him to cross. Allowed. That word was the entire case. But Rebecca preferred another word. Owned. Her attorney paced before the jury. For 37 years, he said, residents have traveled this route openly, continuously, and without interruption. School buses use it. Emergency vehicles use it. Working families depend on it. He turned toward me. Now, Mr. Cole wants to revoke that access because the association refused to meet his financial demands. A murmur moved through the gallery. That was the lie Rebecca had built everything on. I had never demanded money. She had offered it. $4 million for 500 acres of my eastern pasture. The creek, the oak grove, the hill where my parents were buried. When I refused, HOA violation letters began appearing in my mailbox. Then came security guards, cameras, road signs, invoices for maintenance work I had never authorized. Finally, the lawsuit. Maple Ridge was not asking only for permission to cross my land. My attorney, Daniel Harper, leaned closer. Let him finish, he whispered. I looked down at the leather folder. The brass clasp had darkened with age. The corners were worn smooth from my father's hands. Inside rested the original access agreement, a recorded county map, and an internal HOA email Rebecca believed we would never find. My grandfather had underlined one sentence in blue ink. If Maple Ridge, its successors, or any representative challenged Cole ownership, all permission to use the road would terminate. No grace period, no permanent easement, no second chance. The HOA attorney returned to his table. Rebecca looked directly at me. Her smile widened. She thought 37 years of tire tracks had erased my family's name from the soil. She thought 400 angry households could turn permission into ownership. I opened the brass clasp. The metallic click was soft. Rebecca heard it anyway. Her thumb stopped moving across the pen. The judge looked down from the bench. Mr. Cole, do you understand what you stand to lose? Yes, Your Honor. And you still intend to challenge the association's claim? I opened the folder and placed the yellowed agreement on the table. Yes. Outside, thunder rolled over the courthouse roof. What Maple Ridge doesn't understand, I said, is that the moment they sued me for my land, they lost the only road leading back to theirs. The Cole Ranch began with 200 acres, a hand-dug well, and a farmhouse that leaned hard enough in winter to make the windows rattle. My grandfather, Samuel Cole, bought the land in 1959 after 16 years repairing freight engines across West Texas. He paid cash, signed the deed with a black fountain pen, and spent the rest of his life buying every adjoining parcel nobody else wanted. Rocky pasture, flooded creek bottom, cedar-covered hills too steep for tractors. By the time my father inherited it, the ranch had grown to 1,100 acres. He added another 400. My earliest memory was sitting beside him in an old Ford pickup while gravel snapped beneath the tires. The cab smelled like leather gloves, engine oil, and the peppermint candies he kept in his shirt pocket. He drove slowly and pointed through the windshield. North Line ends at the cottonwoods. Creek pasture starts beyond that ridge. And this road belongs to the Cole family from the county blacktop to the far cattle guard. At 8 years old, I thought he repeated those boundaries because he was forgetful. At 43, I understood. Land does not move. People move the lines. The road at the center of the lawsuit was built in the summer of 1988. A developer named Charles Denton had purchased 400 acres east of our ranch and planned to build a small subdivision. The problem was access. His northern boundary faced a drainage basin, and the southern route climbed a limestone shelf too steep for school buses and fire engines. Our gravel road was the only practical way in. Denton came to the farmhouse wearing polished boots and carrying rolled blueprints beneath one arm. He asked my grandfather for temporary passage while the county completed approval for a permanent entrance on the north side. Granddad agreed, but he did not shake hands and leave it there. He called a local attorney. My father witnessed the signatures. The county clerk recorded the agreement. It allowed Denton's crews and future residents to cross our land under specific conditions. They had to share maintenance costs, keep livestock gates closed, and acknowledge that ownership of the road remained with the Cole family. The final clause was 3 lines long. If Denton, any successor, or any association representing future residents ever challenged Cole ownership, permission ended immediately. Granddad underlined that sentence in blue ink. Kindness needs boundaries, he told my father, or people start calling it weakness. Denton built 46 homes. Then interest rates climbed, his investors pulled out, and he sold the development before completing the northern entrance. Every new permit application referred to existing legal access without explaining that the access was conditional. The phrase moved from file to file. Copied, stamped, assumed. By the time Maple Ridge formed its HOA, most residents believed the road belonged to the neighborhood. My family never caused trouble because the arrangement worked. Residents drove through. We raised cattle. My father repaired washouts after storms and accepted maintenance checks when the HOA remembered to send them. School buses slowed near the cattle guard. Neighbors waved. Nobody claimed authority over us. Then my father got sick. Lung cancer took him in 10 months. During his final winter, he called me into the workshop and handed me the cracked leather folder. His hands had grown thin, but his grip was still firm. "Read every page," he said. "I will." "No, Nathan. Read it before someone gives you a reason." Rain hammered the metal roof above us. The workshop smelled like sawdust, cold steel, and coffee he could no longer taste. I read the documents that night. Deeds, surveys, tax maps, the original access agreement. I read the termination clause twice. Then I locked the folder inside the steel cabinet beneath my workbench. For 7 years, nothing happened. Maple Ridge grew larger, richer, and more polished. Stone pillars appeared beside the road. Decorative lamps replaced wooden posts. The HOA started calling it Maple Ridge Parkway in newsletters. I ignored that. A name could not change a deed. Then Rebecca Langford bought the largest house in the subdivision. Within 6 months, she joined the board. Within a year, she became president. And the first time she came to my ranch, She brought a development map that removed 500 acres from the coal property, as if my family had never owned them at all. Rebecca Langford arrived at my ranch in a white Range Rover that had never seen real mud. I was repairing a split cedar post near the eastern pasture when her tires rolled across the cattle guard without slowing. The metal bars clanged beneath the SUV. My horses lifted their heads. Rebecca parked 15 feet from me and stepped out wearing cream trousers, a pale blue blouse, and brown leather boots polished brighter than my kitchen table. She carried a black portfolio under one arm. No hat, no water bottle, no reason to be there except business. "Mr. Cole?" she called. I set the post driver against the fence. "That depends." Her smile arrived before she did. Smooth, measured, the kind real estate agents use when they already know what they want from you. Rebecca Langford, president of the Maple Ridge Homeowners Association. I know. That slowed her half a step. By then, everyone in the county knew Rebecca. She had spent the previous year rewriting HOA rules, raising dues, and issuing violations for work trucks, basketball hoops, and American flags that extended 6 inches beyond approved dimensions. She called it preserving standards. The residents called it easier to pay than argue. Rebecca looked past me toward the creek. "You own all of this? 1,600 acres. That is extraordinary." She did not sound impressed. She sounded hungry. She opened the portfolio and removed a glossy development rendering. The paper was thick and cold beneath my fingers. Fresh ink gave off a faint chemical smell. The drawing showed curved streets, stone houses, walking trails, and a decorative pond where my cattle watered during drought season. Across the top, silver lettering read, "Maple Ridge Reserve, Eastern Expansion. To make you a serious offer." She handed me a letter. $4 million for 500 acres. Below the number was a paragraph about rapid closing, tax advantages, and relocation assistance. I read the last phrase twice. Relocation. Rebecca folded her hands in front of her. "We understand this property has sentimental value." Sentimental? I meant emotional. My deed is not an emotion. Her smile tightened. "This county is changing, Mr. Cole. I noticed. Development is coming whether we welcome it or not. Not onto my land." A cicada buzzed from the cottonwoods. Behind us, the Range Rover idled softly, air conditioning humming through the open door. Rebecca studied me for several seconds. Then she pointed toward the gravel road. "Maple Ridge has relied on that route for nearly 4 decades. My grandfather permitted that. Our attorney believes continuous use may have established permanent rights. Then your attorney should read the records." Her expression went still. That was the first moment the mask slipped. Only for a second. Then the polished smile returned. "Everything is negotiable." "No," she closed the portfolio. The clasp snapped shut, sharp enough to make one of the horses flinch. "I hope you understand that refusing a reasonable offer could create unnecessary conflict." "I understand exactly what you are saying." She turned toward the SUV, then stopped beside the driver's door. "You should also understand that Maple Ridge cannot allow one private landowner to threaten its future." I wiped sweat from my eyes with my sleeve. "The future of Maple Ridge is not my responsibility." Her jaw tightened. "The road may already belong to the association." "No, Rebecca. The road belongs to the Cole family." By the end of the month, Maple Ridge claimed I owed $21,400 in fines. I stacked every notice on the kitchen table. Same letterhead, same legal language, same signature at the bottom. Rebecca Langford, HOA president. She thought repetition could turn a lie into authority. I photographed every page, saved every envelope, recorded every call. Then I unlocked the steel cabinet beneath my workbench and placed my grandfather's leather folder beside the growing pile. Rebecca had come to buy 500 acres. When I said no, she decided to take control of all 1,600. What she did not know was that every letter she sent moved her one step closer to losing the only road her neighborhood had. Rebecca stopped mailing threats when she realized I was filing every one of them. Then she sent workers. The first sound reached the house at 6:18 on a Tuesday morning. A drill grinding into stone. Hard. Mechanical. Wrong. I stepped onto the porch with coffee in one hand and saw two utility trucks parked near the cattle guard. Orange cones lined both sides of my gravel road. 3 men in reflective vests were bolting a black steel sign between new limestone pillars. Maple Ridge Private Access. Underneath, smaller letters read, Residents and authorized guests only. The smell of diesel drifted across the pasture. My coffee went cold in my hand. I drove down in the ranch truck and stopped sideways across the shoulder. Gravel cracked beneath the tires. One worker looked up from the drill but did not shut it off. Who authorized this? I shouted. A man with a clipboard stepped toward me. HOA improvement order. This is private property. He glanced at the sign. We were told Maple Ridge controls the entrance. You were told wrong. Silence rolled across the road, broken only by the hiss of the security vehicle's exhaust and the distant bawl of cattle near Miller Creek. I pulled out my phone and began recording. I am notifying every person here that the Cole family owns this road. Remove the sign, the posts, and the vehicles. The clipboard man shifted his weight. We have paperwork. Show me. He handed over a laminated authorization stamped with what looked like a county seal. Temporary Emergency Access Directive. It claimed my cattle gate created an immediate threat to emergency services and granted Maple Ridge authority to supervise traffic until a formal hearing. The paper felt too clean. The signature was blurred, and the county stamp was black. Barlow County used blue. I called the clerk's office on speaker. Rebecca arrived before anyone answered. Her white Range Rover came around the bend fast enough to throw gravel against the limestone pillars. She stepped out wearing a charcoal blazer, sunglasses, and the expression of someone arriving to inspect work she already considered finished. Nathan, she said, you're interfering with a safety project. You installed a guard station on my road. We are protecting residents. From me. From unpredictable access restrictions. I held up the directive. Which county office issued this? The appropriate one. That's not an answer. She lowered her voice. This situation has moved beyond your personal feelings. My feelings aren't recorded at the courthouse. My deed is. The county clerk answered. I read the filing number. Keyboard taps clicked through the speaker. Then the clerk paused. Mr. Cole, we have no directive under that number. Every worker heard her. So did the guard. Rebecca's face did not move, but a pulse jumped beneath her jaw. I turned the phone toward her. You want to explain why your document carries a county seal? She reached for the paper. I pulled it back. That belongs to the association. It was served on me. You're mischaracterizing an internal emergency authorization. You designed an HOA memo to look like a government order. Her sunglasses hid her eyes, but not the tension in her mouth. Around us, residents slowed their cars. Windows lowered. Phones appeared. Too many witnesses. Too late to pretend. Rebecca straightened. If you continue obstructing this entrance, Maple Ridge will seek permanent judicial relief. There is no permanent relief on borrowed land. Our attorneys disagree. Your attorneys also think my tractor belongs under HOA rules. The clipboard man looked toward Rebecca. Ma'am, are we continuing? She stared at me for several seconds. Then she gave him one short nod. Finish the sign. I stepped between the drill and the pillar. No, the guard climbed out of the SUV. His radio cracked with static. The air smelled like hot metal, diesel, and dust. My heartbeat pushed against my ribs, but I kept my voice level. You touch that post again, and I call the sheriff. Rebecca smiled. Thin, cold, certain. Call anyone you want. So I did. The sheriff arrived 20 minutes later and stopped the work pending verification. The workers packed their tools. The guard shut off his engine. Rebecca watched the sign remain half-installed. One steel post standing crooked beside my cattle gate. Before leaving, she stepped close enough for her perfume to cut through the diesel fumes. You should have taken the offer, she whispered. That was all it took for Maple Ridge to turn 400 households into a weapon. Daniel Harper stood beside me beneath fluorescent lights that buzzed like trapped insects. The courtroom smelled of wet coats, floor wax, and coffee that had been sitting too long on a hot plate. Rain streaked the windows behind Judge Whitman while the HOA attorney described me as a reckless landowner threatening the safety of an entire community. He showed photographs of school buses crossing the road, an ambulance near the cattle gate, families walking beside the shoulder. He never mentioned the fake directive. The judge said that issue would be considered later, after the document had been authenticated. Rebecca sat across the aisle in a navy suit, her hands folded over a legal pad. Her blonde hair was perfect. Her expression carried the calm concern of someone pretending the damage had happened to her. Mr. Cole has repeatedly threatened to restrict access, her attorney said. Without immediate protection, hundreds of residents could be trapped. I leaned toward Daniel. I never said that. I know, he whispered. Let him finish. The attorney turned toward the bench. We are asking only that the existing route remain open until the court can determine permanent rights. Only. That word did a lot of work. Judge Whitman adjusted his glasses. Mr. Cole, until this dispute is resolved, you are prohibited from blocking, restricting, or interfering with residential and emergency access to Maple Ridge. The gavel struck once. A clean wooden crack. Rebecca smiled. Outside the courthouse, reporters waited under black umbrellas. She walked straight toward them. Today's ruling protects families from intimidation, she said. Maple Ridge will continue defending the safety and stability of our community. A microphone appeared beneath my chin. Mr. Cole, why are you trying to isolate hundreds of families? I'm not. Then why challenge the order? Because access is not ownership. By sunset, strangers knew my name. By midnight, they knew a version of me that had never existed. My voicemail filled with threats. One caller promised to tear down the gate with his truck. Another said he knew where my cattle slept. The next morning, red paint covered my south fence. Let US out. The letters were 6 feet tall. I stood in the cold mist holding a pressure washer wand while red water ran around my boots. The machine growled behind me. Paint thinner burned my nose. Across the pasture, cars streamed over my road without slowing. Nobody waved. Maple Ridge moved fast after the ruling. Security guards returned to the entrance. They installed cameras on steel poles drilled into my soil. They stopped my ranch hands and demanded identification before allowing them to cross the road leading to my own barns. Then Rebecca sent another notice. Under the temporary order, the HOA claimed authority to regulate all vehicles using the route. My cattle trucks now required advance approval. The absurdity would have been funny if it had not been happening under a court order. I called Daniel. She's acting like the judge gave her the road. He didn't. Then why is she doing this? Because she wants you to react. I am reacting. React on paper. So I did. I photographed every camera, recorded every guard, measured every post, saved every notice. Daniel filed motions to remove them. The hearing was scheduled 6 weeks away. Rebecca used those 6 weeks like a victory parade. She held a press conference beside the half-finished black sign. She announced plans for improved security, expanded landscaping, and future residential development along the Eastern Corridor. My Eastern Corridor. Then Daniel received the HOA's full complaint. That evening, I drove to the family cemetery. The wet grass brushed the truck doors as I climbed the hill. Wind moved through the oak branches with a low wooden creak. I stood between my parents' graves and looked down at the road. Headlights from Maple Ridge formed a bright line across the ranch. Rebecca had the temporary order. The cameras, the guards, the reporters, the angry residents. I had a leather folder and a clause the judge had not yet read. For the first time since the hearing, I did not feel defeated. I felt patient. Rebecca believed the order had given her control. What it had really given her was 6 weeks to create evidence. And she was using every minute of it. The first real break in the case came from a box that smelled like mildew and mouse droppings. It sat on the bottom shelf of the Barlow County Archive beneath 3 decades of drainage reports and abandoned subdivision plans. The label had almost faded away. Maple Ridge. Original access. Daniel and I had been in that basement for 7 hours. The fluorescent lights buzzed overhead. Dust clung to my sleeves. My fingertips had turned gray from handling carbon copies and brittle maps nobody had touched since my grandfather was still alive. Daniel loosened his tie and looked at the clock. "One more box," he said. I dragged it onto the table. The cardboard sagged in the middle. Inside were soil reports, road width calculations, and letters from Charles Denton's original development company. Most of it was useless. Then I found a folded county memorandum clipped behind a survey plat. Denton sold the project after 46 homes. Every owner after him expanded the subdivision by copying the phrase existing legal access from one application to the next. Nobody explained that the access was conditional. Nobody checked the recorded agreement. The mistake had been repeated for nearly 4 decades until repetition began to look like law. Then I unfolded the attached plat. A 60-foot dedicated public right-of-way ran from County Road 12 to the northern edge of Maple Ridge, straight across Lot 1. Rebecca Langford's property. Her house stood back from the route, but the stone fountain, front hedge, and half of her circular driveway had been built directly inside the corridor. Daniel leaned closer. "There's a transfer disclosure." I followed his finger. "Access right OFWay acknowledged by buyer." Rebecca had signed it when she purchased the property. That was why she wanted my road. Not because it protected children. Not because it improved emergency response. Because the legal entrance Maple Ridge should have built 37 years ago crossed her front lawn. The next morning, Daniel served discovery requests for every HOA email, board memo, legal opinion, and development proposal involving my ranch. Rebecca's attorneys fought us on all of it. Judge Whitman ordered production. 3 weeks later, 12 digital folders arrived. Most contained landscaping complaints and arguments about mailbox colors. Then Daniel called me at 11:46 one night. "I found something." His voice had changed. I drove to his office through hard rain. The windshield wipers slapped back and forth. Lightning flashed over the highway, turning the fields white for half a second at a time. Daniel was waiting in the conference room with one email open on the wall monitor. Subject: Northern Access Liability. Rebecca had written it 10 months before she offered to buy my land. The current route is a revocable license, not a permanent easement. Any direct challenge to coal ownership may terminate access under the 1988 agreement. I stared at the screen while the computer fan hummed. She knew. She knew about the corridor. She knew about the termination clause. She knew exactly what could happen if Maple Ridge challenged my title. Daniel printed the email. The page slid from the machine warm enough to curl at the corners. "This proves intent," he said. "It proves fear." He looked at me. "What are you thinking?" I opened my grandfather's leather folder and placed the original agreement beside Rebecca's email. The blue underline had faded, but the words remained sharp. Any challenge to coal ownership terminates permission immediately. "We do not lead with this," I said. Daniel's eyes narrowed. "You want Rebecca on the stand first. I want her to claim the road belongs to Maple Ridge. If she denies knowing the agreement, we show the email. If she admits knowing it, she admits she filed the lawsuit anyway." A slow smile crossed Daniel's face. "Either way, she destroys her own case." Thunder rolled beyond the windows. I looked at the county plat, the recorded right-of-way, and the email Rebecca thought would stay buried. For weeks, she had used the court order to make herself look powerful. Now we knew the truth. She had not sued me because she believed the road was hers. She sued because she knew it wasn't. And when she finally said otherwise under oath, I intended to let her close the gate herself. Trial began on a Monday morning under a sky the color of old steel. By 8:30, every bench in the courtroom was full. Maple Ridge residents packed the gallery in pressed shirts, wool coats, and expensive shoes still dark from the rain. Cameras waited outside beneath the courthouse awning. Inside, fluorescent lights hummed above the jury box, and the air smelled like damp fabric, copier toner, and burnt coffee. Rebecca sat at the plaintiff's table in a white suit. Pearl earrings. Half a circle. Stop. She looked calm. The pen said otherwise. Daniel placed 3 folders on our table. The first held the original 1988 access agreement. The second held the county plat and the dedicated northern right-of-way. The third held Rebecca's emails. He tapped the last folder once. Not until she commits. I nodded. The clerk called the case. Maple Ridge Homeowners Association versus Nathan Cole. The words echoed against the wood-paneled walls. Their attorney opened with photographs. A school bus crossing my road. An ambulance near the cattle gate. Children waiting beside the shoulder. He spoke about safety, reliance, and community stability. He called the route a neighborhood lifeline and described me as a private landowner trying to use an outdated technicality against 400 families. He never mentioned the fake directive. He never mentioned the 500 acres Rebecca had tried to buy. And he never called the road Cole property. That was deliberate. Then Rebecca took the stand. Her heels clicked across the floor. She raised her right hand, swore to tell the truth, and sat beneath the witness light with her shoulders straight. Her attorney approached. Mrs. Langford, does Maple Ridge consider the access road part of the association's property? Yes. No hesitation. Has the HOA maintained it? Yes. Regulated it? Yes. Controlled its use? Yes. And does Mr. Cole retain any legal right to revoke that access? No. A quiet murmur moved through the gallery. Daniel wrote one word on his legal pad. Committed. Cole $4 million for 500 acres. Her fingers tightened around the witness rail. Before, perhaps. And why did you want that acreage? For responsible community expansion. Not because Maple Ridge lacked permanent legal access? No. Daniel walked toward the evidence table. Did you send an email titled Northern Access Liability? Rebecca's face changed. Barely. A slight tightening beneath the eyes. I send many emails. Did you write, we need permanent control of the existing road before he understands his leverage? Her attorney stood. Objection. Overruled, Judge Whitman said. Daniel waited. Rebecca swallowed. I would need context. You'll have it. He opened the third folder. The printer paper sounded sharp in the silent courtroom. Her email appeared on the screen behind her. Every word filled the wall. Someone in the gallery whispered, Oh my God! Daniel faced her again. You knew the existing road was a revocable license. I knew there were legal questions. You testified 10 minutes ago that there were none. I said that was my understanding. So your understanding changed after you took the oath? The silver pen slipped from her fingers. It struck the floor with a small metallic click. No one moved to pick it up. Daniel opened the second folder. The original county plat appeared next. The unfinished northern entrance. The 60-foot dedicated public right-of-way. Rebecca's property beside it. Langford, you filed this lawsuit to establish that Maple Ridge owns the road. Yes. And you testified under oath that the Cole family has no right to revoke access. Yes. Daniel placed the agreement on the screen. The blue underline was still visible. Any challenge to Cole ownership terminates permission immediately. Judge Whitman leaned forward. The gallery stopped breathing. Daniel read the clause aloud, then looked directly at Rebecca. Mrs. Langford, your lawsuit did not secure permanent access. He paused. It terminated it. The judge did not touch his gavel. He reached for the agreement instead. That was when Rebecca Langford finally stopped pretending she was in control. Judge Whitman removed his glasses and read the yellowed pages in complete silence. Rain tapped against the courthouse windows. The ventilation system pushed cold air across the room, carrying the smell of wet coats, copier toner, and polished wood. No one in the gallery moved. Daniel stood beside the evidence screen with one hand resting on the table. Rebecca's attorney leaned toward her and whispered behind his palm. She did not look at him. Her eyes stayed fixed on the blue underline beneath my grandfather's words. Any challenge to Cole ownership terminates permission immediately. For months, Rebecca had called that sentence outdated, irrelevant, a technicality. Now it was the only sentence in the courtroom that mattered. Judge Whitman looked up. Counsel approach. He found that the Cole family held clear title to the entire 1,600 acres, including the gravel road connecting County Road 12 to Maple Ridge. He found no permanent easement, no transfer of ownership, no legal basis for the HOA's cameras, guards, signs, development corridors, or utility claims. Then he addressed the termination clause. The 1988 agreement created a conditional license, he said. Maple Ridge initiated a direct challenge to the Cole family's ownership despite written knowledge that such a challenge could terminate its access. A woman behind Rebecca gasped. Her attorney stood. Your Honor, immediate termination would create a public safety emergency. Judge Whitman's expression hardened. An emergency the association knew about before filing this lawsuit. We request a stay. You will receive a limited transition period. For 1 second, relief crossed Rebecca's face. Then the judge continued. 30 days. Residential and emergency traffic only. No HOA security, no construction equipment, no expansion activity, and no assertion of ownership. The relief disappeared. After 30 days, he said, the contractual license terminates completely. He ordered Maple Ridge to remove every camera, sign, post, and guard station from my property within 72 hours. He awarded damages for the drilled road shoulder, the unauthorized installations, and the altered fence line. Then he referred the fake emergency directive and Rebecca's testimony to the county prosecutor for review. The courtroom went silent. The gavel fell. One strike. A clean wooden crack. Rebecca flinched. Outside the courthouse, reporters crowded beneath black umbrellas. Microphones rose as she stepped through the doors. Mrs. Langford, did you know the HOA could lose access? I always had the ranch. The difference was that the court had finally said it aloud. By sunset, workers were removing the Maple Ridge private access sign. The drill screamed one last time. Steel posts came loose from my soil. Security guards packed their radios into the black SUV and drove away without looking at me. I stood beside the cattle gate while residents passed under the 30-day order. Some stared straight ahead. Some looked angry. One older woman lowered her window. We didn't know, she said. I looked toward the empty holes where the sign had stood. You never asked. On the 30th morning, I walked to the gate before sunrise. Fog rested low over the pasture. Gravel crunched beneath my boots. The steel latch felt cold in my hand. Behind me, 1,600 acres stretched beneath a pale Texas sky. Ahead of me, Maple Ridge waited in silence. I closed the gate. The latch dropped with a metallic click. Not loud, not dramatic, just final. Rebecca had sued me to control my land. Instead, she handed me a court order confirming the road had always been mine. Rebecca Langford resigned at 9:12 the next morning. Her email reached every Maple Ridge resident less than 3 hours after I closed the gate. It was 2 paragraphs long. She blamed media pressure, personal attacks, an increasingly hostile legal environment. She did not mention the fake directive. Residents had paid for it through 2 special assessments labeled future access improvements. They thought they were funding road safety. They had actually financed Rebecca's attempt to take control of 1,600 acres. The emergency HOA meeting lasted almost 5 hours. I did not attend. Daniel called me afterward. 4 board members resigned, he said. The management company froze the discretionary accounts. And Rebecca? She left before the vote. Of course she did. A week later, the new HOA president came to the ranch. His name was Michael Turner, a 60-year-old civil engineer with tired eyes and red dust on his boots. He parked outside the gate and walked the final 100 yards carrying a plain paper folder. No attorney, no reporters, no security vehicle idling behind him. He stopped in front of me and removed his hat. Mr. Cole, Maple Ridge owes you an apology. Wind moved through the cedar trees. I waited. Most of us believed what Rebecca told us, he continued. You believed it because her version was easier. Michael nodded. That's true. The answer mattered more than an excuse. He opened the folder. Maple Ridge offered to pay my legal fees, repair the drilled road shoulder, replace the damaged fence posts, and remove every remaining piece of HOA equipment from coal land. They also requested temporary access while construction began on the northern public right-of-way. 90 days, Michael said. 30. His mouth tightened. We cannot build a county road in 30 days. You had 37 years. We settled on 45. Not because Maple Ridge deserved another favor. Because children still needed school buses. Nurses still worked night shifts. Construction on the northern entrance began 11 days later. The dedicated public right-of-way crossed the edge of Rebecca's property exactly where the 1988 county plat showed it. Workers removed the stone fountain first, then the hedges, then half of the circular driveway. Bulldozers groaned outside her windows before sunrise. Diesel smoke drifted across the lawn. Orange survey flags appeared in a straight line beneath the white columns of her porch. I never drove over to watch. I did not need to. The sound carried across Miller Creek. When the new entrance opened, Maple Ridge held no ceremony, no ribbon, no speeches, just a line of cars moving across fresh asphalt while the temporary access notice disappeared from my cattle gate. That evening, I drove to the family cemetery. The leather folder rested on the passenger seat. Warm grass brushed the truck doors as I climbed the hill. The air smelled like cedar bark, red earth, and rain gathering beyond the western ridge. I sat beneath the oak tree between my parents' graves. The original agreement lay across my knees. My grandfather's blue ink had faded. The words had not. Permission is not ownership. Below me, 1,600 acres rolled toward the highway in long green folds. Cattle moved near Miller Creek. The repaired fence caught the final orange light. No cameras, no guards, no Maple Ridge signs. Just land carrying my family's name. Developers called after the verdict. The offers doubled, then tripled. I rejected every one. Rebecca believed anything could be taken if enough people repeated the same lie. She never understood that history does not become weaker because it is quiet. Maple Ridge sued me for my 1,600 acres. After trial, they lost their only access. Justice did not shout. It waited inside a cracked leather folder for 37 years. Then it spoke at exactly the right moment.